He's called her 195 times.
What?
Yes. And
Did you say 195?
yes.
Oh.
And even one of the calls, he said, email the judge and the prosecutor and the lawyer. And that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey.
Oh, no, we're not going to say that here. Both privileges are hereby ordered revoked.
Okay.
Defendant's bond is set at no bond.
Good morning again, Your Honor. Andrew Meyer on behalf of Joseph Taylor. Mr. Taylor, could you state your name for the record?
Joseph Taylor.
Thank you. Your Honor, this is time and date set for probable cause conference. This time we're asking the court to set this for the next available preliminary exam date.
Discovery is complete.
To my knowledge.
People had their witnesses available the second.
Yes, Your Honor.
Preliminary examination will be set July 2nd, 2024, 9 a.m. That is in person before Judge Washington.
And then to address bond for his.
Yes, go ahead.
He has been contacting the victim in this case, and we also ask you to report his jail phone call privileges. He's called her 195 times.
What?
Yes. And
Did you say 195?
yes.
Oh.
And even one of the calls, he said, email the judge and the prosecutor and the lawyer. And that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey.
Oh, no, we're not going to say that here. Both privileges are hereby ordered revoked.
Okay.
Defendant's bond is set at no bond.
I don't give a fuck.
Okay, he's now in contempt. That's 93. Anything else?
I think at this time, Your Honor.
Okay, I'm going to need an order. Contempt. You got 93 on that. His bond's been revoked. It's 0, and he's got a preliminary examination. Good luck, Judge Washington. Court calls the case, People versus Jaquan Turner. You probably don't want to come out here right now, do you? No. Go ahead.
The back today, Your Honor. Turner, can you please state your name for the record?
Jaquan Turner.
Thank you.
And Your Honor, we are just waiting today, so.
He's waiving preliminary examination.
Yes, Your Honor.
Is that correct, sir?
Yes, sir.
And you understand the preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand you will not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination haven't been waived. Defendant is bound over to circuit court on a single count.
Thank you, Your Honor.
No, he's got to do the rest of it.
I'm sorry. Yes, it's just we're trying to avoid any conflict, apparently. I apologize, Your Honor. As for the as to that, Your Honor, acknowledge receipt of information. We stand mute, wait for
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for July 9, 2024, 1:30.
contact. Thank you, Your Honor.
You can leave now.
All right.
Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes,
Okay, could you please state your name?
thoroughly.
What is that noise?
Shouldn't you check? I don't feel safe.
What
Why are
is,
you just pointing? What?
Don't stop. So.
It'll stop at some point.
I feel very safe, Your Honor.
Oh, I know. He's like, you are all over it. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasney. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange of a pending case where Mr. Quasney is the defendant of an AMB against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want to document it for potential additional charges. But this all happened, transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one of you listened?
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this
Well,
case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's her name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself, and I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the call.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication, there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Kwanzi agrees not to testify in this case.
So I have the text messages.
Before further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text
He
messages.
might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, right, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right.
Okay.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that. Your Honor.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
Thank you, Your Honor.
Thank you, because I want to go to work. I said, Lord, if you let me be out of here by 1:30, I don't have to call off because I need the money.
You are just gonna hold church up in here, aren't you? All right. What's your name?
Regina Agnew.
All right, thank you. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $1,504.90.
All right, Ms. Agnew, how are you intending to get it?
I talked to Robert G earlier, this morning about 10ish, and I went on the portal because he straightened some things out for me where I can go in, and I paid $200.90, which came out to $206.91 because of 2.99%. That's a lot of extra money. $6 is a lot in this economy. But anywho, to make that payment, I had stated to him that on the 20th, I would make a payment again, and I will be all paid up by the 27th. Okay. So on next Friday, I will make a payment of $550 and the remainder on the 27th. Now, what I would like to say is, I understand business is business and they need their money. When I moved in the end of March, six days before the end of March, my door is, how would you say? I would say jimmied by the maintenance person, the sliding door, where if someone really wanted to get in my home, they could. And if I could just put it in escrow so they know that, okay, I know it's business, you bringing me to court. Yes, I owe you this. Yes, I do. But please make sure that my living quarters are good per the state guidelines as well, because they told me that it would take the guy that came out and measured the door. You can. The gentleman that came out and measured the door said that they had been telling them Empire Management with the prior tenants that lived in that particular unit that I'm in now, that they would need to replace the door. And the door has not been replaced yet. And today is, June 13th. Thank God I'm not superstitious. And it has not been replaced. So to be fair,
you need the door replaced.
I need that door replaced. I haven't been holding funds because of that. It's just other things that's been going on. And I just returned back to work on this past Tuesday due to.
What do you do for a living?
I'm in the auto industry, 26 years, auto industry. Yeah, I know they say, oh, why she in court? To all the,
no, I didn't.
Not you, Your Honor, but to all the, because there's some people out here that watch this landlord tenant stuff that don't work and they just want to, such and such was in court because they owe for this, but it's real out here. And mental health is real. I have lost people, but I'm saying this for the viewers too.
Oh, so now you go ahead, girl. You know what? I cannot stop you. Just go ahead. I figured she wasn't talking to me, so go ahead.
No, you good. You're right here. You're right here with me. You're right here with me. You just make me nervous. Well, I have to keep going back to the bathroom while I tell my neighbor. If they call my name, please tell them I just went to the restroom. But I haven't been holding money due to what they owe, but they're coming down hard on me. So since we're gonna be hard about it, please take care. You shouldn't even okay for me to move in when I did and things was not taken care of. That's all. That's all I'm saying. But I will have this satisfied by the 27th, and I look forward to seeing you. If I have to come back in here in court, I hope not, because my shift started at 2:30. And I don't have to call in because God is good, because I'll be out of here. But we as people
You
in the
just let me know when
industry-
you're finished. 'Cause
So we as people in the auto industry, we go through things too. I just want the viewers to know. Yes, I thank God for my employment. I was able to raise my children up on it, but there is things that goes on in life.
Okay, all right.
Thank you, Your Honor. I appreciate you.
And you. Did you want to say anything, Miss?
Your Honor, I don't know if I can follow that up. Is it the latch? It's just not latching?
It's
Or-
what it is it's the sliding door, and so you have the door that latch, but the back side of it is a
Okay.
gap. Rodents can get
Okay.
in, so they put
Okay.
cardboard in there.
I see.
And they
Okay.
told me they ordered the door, it would take 6 weeks. So we're 6+ weeks out. And I just need communications, everything, like they tell me, and I agree.
Thank you.
But I'm not holding rent because of that, but
Yeah,
since
no,
we
right.
in here, let's have a conversation about it. Respectfully.
Yeah.
Respectfully.
Okay, did you want, you mentioned, I almost don't want,
Escrow,
you want to put it in court escrow?
and I do.
All right, so you need. to
Next
print-
Friday, I will come to the courthouse and I will put that $550 in. And the following Friday, on the 27th, I will pay the remainder. And I tell you, Your Honor, you will not see me out of good faith in July, because July will be on time.
Thank you, ma'am.
You're welcome.
All right,
I appreciate you. I do.
June 27th, 2025, 2 p.m. All right,
Okay, thank you.
you take care and
All
know,
right.
they'll make
Bye-bye.
sure to
Have a
get
great
in the door. Really? Oh, my God.
Court does call the cases of the people versus Quincy Jones.
Hey, Richard McDuffie for the people.
Cameron Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones.
All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you were charged, what you're charged with?
Okay,
Do you?
I understand that.
All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you gonna test clean?
For what?
Mr. Allen. Mr. Jones, what's gonna be in your system? Because I can't arraign you if you're under the influence of something.
I
So
know
you might as well just tell me.
some marijuana,
And what else?
probably a little bit of cocaine.
Appropriate bit of cocaine. When did you take that?
Be truthful with you.
Huh?
Yeah, I'm be truthful with you.
Okay, so when did you take the cocaine?
About 2 or 3 days ago, so it ain't on my system yet.
Seriously?
Yeah.
So when's the last time you had any marijuana? You're on something,
Yesterday.
you're on something right now. What are you on? That you,
What do you mean, like,
The worst thing is to lie to me.
what do you mean, what do you mean, like, on something? Like, what do you mean? Like, did I do something to get today or,
I don't think that's really a hard question.
oh, I smoked some marijuana last night.
Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bonds revoked, defendants remain.
Thank you, Your Honor. I. I'll put the answer approach.
Why?
You can wait till.
Good. That works. And I'm gonna set that for the